Thank you for returning to the 24th Annual George Mason Law Review Antitrust Symposium. I'm Judge Douglas Ginsburg, and this is the second of two sessions today. Earlier this afternoon, we heard from Professor Tad Lipsky and three distinguished panelists who discussed the ongoing big tech cases. And so, although this panel is going to be about litigation, 2021 and beyond, we are going to be distinctly not talking about those pending cases. Our panelists today are extremely well qualified to address the future of litigation, the immediate future of antitrust. And they are, in alphabetical order, Melinda Coolidge from the Hausfeld firm, Julie Elmer from Freshfield's Bruckhaus, Deringer, US, Laila Harder, an economist from Charles River Associates, Laila Harder, and Daniel Matheson of the Federal Trade Commission, Bureau of Competition. Now, litigation, as we look forward to 2021 and beyond, antitrust litigation is going to be, if not directly affected by, or sort of conducted under the not cloud, but the shadow or what have you cast by the pending legislation in the Congress, particularly Senator Klobuchar's bill, which would affect antitrust litigation very directly, profoundly perhaps, in many ways. And so we want to pay particular attention to the changes that the bill would work if enacted, and how that compares with where we are and have been historically. So for that purpose, I'm going to turn first to Melinda Coolidge, who's going to start us off with some insights about the preamble to the bill. It seems like a logical place to start, and you're about to find out why. Melinda?
Thank you, Judge Ginsburg, and thank you, George Mason. So Senator Klobuchar's bill really, I think, tries to encapsulate and solve many of the problems that have been raised with antitrust law, and goes through and resets, I think, cabins the consumer welfare standard differently than how it has been cabined by courts over the last decades. The bill makes clear that no longer is the only thing that matters is the price to consumers right now low. And instead, it looks at what are all of the effects of competition in the marketplace, and what are we trying to achieve through antitrust laws. So the preamble points out that quality of goods, choice of goods and services are also important benefits of competition. And it also points out that the presence and exercise of market power makes it more difficult for people in the United States to start their own businesses. It depresses wages and it increases economic inequality. And I think, although I think that those statements wouldn't be debated, the antitrust laws have kind of gone away from that more holistic view of the benefits of competition. And I think the preamble will allow courts to recognize a broader test than what is now the traditional price-only consumer welfare standard. Go ahead.
Melinda, at an earlier session in the symposium, former Chairman Kovacic was quite adamant in suggesting that, in saying that that the portrayal of the consumer welfare standard as being limited to price was not only inaccurate, but sort of misleadingly, what shall I say, derogatory about the cases and the efforts that have been made with respect to quality and to innovation, and he cited several cases on each point. Does the bill not even acknowledge that or appreciate that preamble?
Well, I did hear about that, those statements, and I don't disagree that the consumer welfare standard shouldn't be seen as only price. But the fact is, this is one of the reasons why, and I know you said we wouldn't talk about big tech, but why big tech has gotten to the place that it has, because so much of the product and service that it offers is, in one sense, free. And so it has made challenges to the market power of these massive companies more difficult to make. And the bill does not say, I'm overruling the consumer welfare standard, or price doesn't matter. It absolutely recognizes that price matters. I think that it just properly lays out, like, let's not make it all about price in the short term. There's a lot that that should be looked at. And it's not saying, we've been failing to do it, but I would say we've been failing to do that.
Sorry. Can you comment on that without reference to the pending tech cases?
Yeah, I'd love to jump in and comment on that. As a former government enforcer, I left the government about 6 months ago, but based on my time at the DOJ, I think the agencies are concerned with quality and innovation. I know I personally was involved in filing a case where a reduction in innovation was one of the primary harms that we alleged in the complaint. There's an opinion, it's the Anthem opinion from the district court there, blocking that merger for a variety of reasons. But in that opinion, the court stated that a reduction in innovation is itself a harm to competition. So I think that the existing antitrust laws do recognize that there are different ways to measure competitive harm. And I think the agencies are already aware of that. And we don't necessarily need a new bill in order to effectuate that.
But I think from what you said, Melinda, that even with all those points made, the bill would authorize still more considerations, not just innovation and quality.
I think that's right. I mean, I think it's always just useful to have the courts be able to look to Congress, and it's certainly, no fault of the agencies. I think it's more, well, and I'm mostly speaking about in private litigation, the kinds of defenses that are put forward but price is low.
Right, right. Although I'm not aware of any case that was dismissed because prices were, there was zero price involved. Maybe it deterred someone from filing such a case. Well, that's the preamble. Let's get into the weeds a little bit. So the bill would erect, or perhaps I should say reverse, burdens that we're used to, a sort of reversal of the presumption that a transaction is benign, if not pro-competitive, and that the government has to, or the plaintiff, in government or private, has to defeat that presumption with a showing. How would it work if the bill actually does, as I'm describing it, reverse that presumption? How does that work, or how might it work in practice? Julie?
Yes, thank you, Judge. So the bill would really do two different things. It would lower the burden of proof. And so what that means is that the government would not have to show that a merger is likely to substantially lessen competition. The government would only have to show that a merger would create an appreciable risk of materially lessening competition, and materiality would be defined as more than de minimis. So it's a squishy standard, but it's a more relaxed standard than the one that we currently have right now. And then in certain circumstances, the burden of proof or the presumption would be switched. And those circumstances include the following: where the merger would significantly increase market concentration, where the firm, one of the firms that's involved in the transaction, has more than 50% share and they're acquiring a nascent or maverick competitor where a deal is worth $5 billion or more. And that includes in a situation where there's no horizontal overlaps. So in that situation, the AT&T Time Warner deal that was allowed to go through, that would be presumptively considered illegal under the new bill, as would the Amazon Whole Foods merger. So that could potentially have a really great effect on vertical deals of a certain size and would be a sea change from where the law is today. So I think you're probably likely to see more abandonments. I think you're also likely to see merging parties really make an effort to get their ducks in a row, line up their witnesses, and be prepared to meet that presumption where they're really serious about moving forward and seeing their deal through. I think that the increased risk of a swap or a flip in presumption will show up in the terms of merger agreements, should a bill or anything like it is in its current form be passed.
Can you, or indeed can anybody, point to another area of the law from which a court could draw some insight into what it means to create an appreciable risk of materially doing something?
I think there's going to be so much opportunity for litigation here. We've got all these terms that are very poorly defined, or just waiting for a couple of teams to get in there and fight over them. So it will be a field day, I think, for merger litigators going forward if a bill like this gets passed.
Anybody else on this particular point?
I would just say, if we think about what the Sherman Act and the Clayton Act have always said, it's not much, right? And so the courts have had to interpret a lot of things, and that's what cases are for, right? We figure out what makes sense when there are facts to apply, and courts figure it out and agencies figure it out. And I'm not sure appreciable risk is any more problematic than just the two sentences of the Sherman Act.
And I do think that Congress has tried to provide the judiciary and all of us faceless bureaucrats, by which I include myself in Washington, with some guidelines about how to instantiate these presumptions. I think it's very interesting, as Melinda pointed out, that the findings and purposes of this legislation focus on market power. And I don't think this is an uncontroversial point, but they find, as a reason for passing this legislation, market power is substantial, market power is increasing, and that the use of market power is causing all sorts of problems with democracy and distribution of income. And so I feel like Congress is telling us that the politically accountable branches are detecting serious problems with market power that are not captured in our current ability to model direct consumer harm from transactions. And they're trying to provide some guideposts through which enforcers and the judiciary can start pushing back on what is viewed by the politically accountable branches as problematic increases in market power.
As I understand it, wherever there's a provision of the bill providing that wherever the term monopoly appears, there will be inserted or monopsony. So I presume that would be applicable in a case in which the sort we're talking about, where the presumption's reversed and the criteria are met, the 5 billion or what have you. What would be the implications of the including or monopsony in the pairing it with monopoly?
My personal view is we're going to have some difficult market definition exercises we haven't had to engage in thus far, both on the employer side and on the purchase of assets side. One of the things that the bill specifically notes is that the increase in monopsony power has led employers to be able to drive down wages. I think that's going to be a pretty tough market definition exercise, but not insurmountable. I do find it interesting, as we briefly discussed, these merger changes only apply to suits brought by the government, brought by the United States, the Federal Trade Commission, or states. And so it doesn't create a free-for-all for unions or other interested parties to start attempting to attack mergers, which I find interesting because that same limitation, ensuring that a government actor or a politically accountable actor brings the case, does not apply to the exclusionary conduct prong of the bill, which also might have significant implications for how especially large companies are going to conduct their business. And that is going to be, I think, a much more sort of Wild West, if this bill ever gets passed, approach, because there's a lot of interesting cases that can be brought against large companies by any excluded rival under any number of theories that, an allegedly anti-competitive practice is increasing market power.
Are there not monopsony cases already brought under the existing law? Was Weyerhaeuser a monopsony case?
Predatory bidding. There's Blueberry monopsony case. There have been monopsony cases brought under the present law. I think what this is telling us is that if you can define a market and there's a 50% or greater concentration, then acquisitions are going to be presumptively problematic. So if someone is acquiring more than 50% of what we're going to call a relevant market, it is going to significantly change how the government would look at mergers in those spaces.
The other day, a student put to me an interesting hypothetical in which one could imagine monopsony in a labor market, where the labor is provided by independent contractors, gig workers, rather than fully indentured labor employees. The idea being that in a given geographical market, there is some ascertainable pool of actual and potential gig workers. And one can imagine, if Uber and Lyft are merging, that could have that effect, a monopsony effect on that labor market. Seems plausible. All right.
I've been thinking about labor markets too, and I always think of them in geographic terms, but it's kind of interesting to wonder how the after effects of this pandemic will impact labor markets and whether or not you can really limit a labor market to a specific geographic area anymore, at least in certain, maybe financial services or white collar jobs where a lot of the work can be done remotely.
So it would be, yes, not the conventional geographic metes and bounds, but some way of determining what the pool of potential or qualified people is.
Exactly.
Yeah, well, that's very interesting. Laila, have you looked at anything like that?
Even absent the pandemic, those particular issues that definitely complicate things further. But when it comes to labor, there's a great deal of mobility in the United States with respect to labor, and so there will be, these are tricky questions to figure out what is what is the pool of workers and where are all the places you can draw them from. So certainly will make for interesting analyses.
Well, we did see thousands of workers moving to the Dakotas, to the oil fields newly developed in the Dakotas. Although I think they were typically single men who were not moving their family or even themselves on a permanent basis, or rather were working, as people work on offshore oil rigs for a period of time and then they're rotated back. So, I mean, if that kind of mobility is unusual, right? I mean, you don't expect large swaths of the public to sell their homes or apartments and move for all of a sudden to accept jobs. Right,
and I guess I was thinking more of, even when you think of skilled labor, it's not that the geographies will be very localized, because people do, depending on, of course, every time it'll depend on the facts and the circumstances of the particular industry and the labor market. But of course, there's mobility across the states, to a significant degree, depending on the type of job and industry.
Yeah, I saw Maureen Olhausen actually brought out the degree to which interstate mobility has been inhibited by occupational licensing for so many trades. She said at the end of World War II, 5% of the labor force was in a licensed occupation, and it's now north of 25%. And of course, there's almost no reciprocity across states. It's starting now. And the particular plight of military spouses is what's, I think, making a difference. I'm not sure that this was covered in what we discussed about the presumption, but there's a statement here that about having a 50% market share or otherwise having significant market power. Now, on what would we draw? And to what would you point a court for evidence of significant market power absent a 50% market share, or other than a 50% market?
I mean, I think the way the bill looks at market definition, which I think we're also going to get to later in our talk, is probably reflective of the intent, which is, you know, if the government is able or the plaintiff is able to establish direct evidence of the exercise of market power, and you can do that with the testimony of witnesses, you can do that with party documents that reflect the market power. So, you know, I think that that's an area where you're going to have anecdotal evidence that reflects the exercise of market power. We know already under our existing regime that market shares can sometimes overstate the competitive significance of a firm, but they can also understate them. You know, you've got your failing firm, flailing firm cases. On the other hand, you may have a nascent competitor that punches above its weight. And so I think that this provision in the bill is probably reflective of these types of cases.
There's a group of cases, I think it's about 60 or so cases in which the Philadelphia National Bank presumption of 30% has been discussed. And although it's been applied in a few cases, it's more often been set aside on the ground that the market conditions, that the percentages do not accurately reflect competition in a particular market. So that's certainly been a feature already with respect to overcoming a 30% barrier. Although it's, Josh Wright and I wrote about this in 2013, which was the 50th anniversary of PNB. 30% seems to me like a perfectly sensible processing rule for an agency, as opposed to a rule of law. But I don't know, Dan, does that make sense to you?
As far as something to guide the agency's discretion, it does make sense. I don't know if you'd want to throw it out as just providing the court with a foothold for when we start to worry about, when market concentrations become significant. And I think, in a lot of cases recently, certainly the FTC has been bringing cases that dramatically exceed the Philadelphia National Bank presumption. One interesting thing about market power, I mean, the way the bill defines it is the ability of a buyer or seller to demand conditions that it could not get in a competitive market, which seems kind of circular. How in the world are you supposed to know what conditions a buyer or seller could extract in the competitive market? Do you just go ask people? If you had more than one option, would you prefer to give them this condition? So it seems, I do agree with Julie that certainly elsewhere in the bill also, it explicitly states that direct evidence of market power is sufficient, that you don't have to define markets. In all cases, I think that was already in the law. That's already in Indiana Federation of Dentists. It's something the FTC has argued for quite some time, but it might help to clarify that. I don't think that changes things. It does change things to, in my mind, presume market power anytime someone demands something its trading counterparties would prefer not to give and then gets it. It seems very hard to draw the line between a good negotiator and somebody who's now going to be presumed to have market power, because it's able to insist on a cross license to your patents, or it's able to insist on a most favored nation clause. So I do think it's an interesting area to ask. What does it mean if I can't show they have 50% market share, but I show they're able to walk around and bully everyone into giving them something they prefer not to give? Well, maybe they're offering a lower price in exchange for some form of MFN or exclusive dealing. And so I do think that's going to be an area in which there's going to be an awful lot of fights before we figure out what the final rule is.
I think it certainly flies in the face of some of our existing case law about how competition is hard. And, you have some of these Scalia Supreme Court opinions about sharp elbowed competition and I just think it'll be interesting to see how that plays out with our Supreme Court.
I think the test is actually kind of similar to just the test of whenever you're doing kind of a but-for model. So if they can demand something that's more favorable than what they could demand and profitably obtain it, and they wouldn't have been able to obtain those terms in a competitive market, then you're doing tests like looking at, okay, so before they bought that nascent competitor, they weren't able to demand that, or before, you do some kind of before test, right? When things were more competitive, could they have demanded that and got it, right? And then you do expert analysis and you look at, whether it's likely they would have achieved that. I think that should, you can always have courts that have crazy decisions, but I think that should solve the problem of, are you just a good negotiator, right? If they were just a good negotiator, then they would have been able to negotiate in a more competitive market as well.
But for becomes a lot easier when it's but before.
It does.
Ordinarily, or not ordinarily, but often that is not available. And if you're looking at a prospective merger, proposed merger, you don't have the you are in the before already. But it seems to me that I really appreciate the reaction of people who litigate. That one way of looking at it, and might be tempting for courts, is to look at what the EU does with regard to dominant firms. The definition of dominant firm being that it has the ability to act independently of the constraints of constraints imposed by competitors or consumers. Right, so it's sort of just another formulation, perhaps, for market power, but it cuts into it in a different angle, at least.
In both exclusionary conduct and in mergers, I think the FTC brought a case against Ovation some years ago, in which the theory was essentially you're able to avoid reputational harms by transferring a drug from someone who is subject to repercussions if they jack up the price of the drug versus some fly-by-night operation that doesn't care. And I think you could have a lot of transactions that might allow you to avoid reputational harms or repercussions from consumers that would become problematic under that view, even though we wouldn't necessarily understand them as giving rise to an increase in market concentration. It would just relax a reputational constraint or relax an ability of somebody to retaliate. So you could, under that definition, think that does give rise to market power and the ability to exercise it when the firm prior to the merger just didn't have the ability to exercise its market power profitably, to Melinda's point.
Interesting, very interesting. What about this provision in the bill, Dan, dealing with civil penalties?
So the civil penalties are interesting. It would provide for civil penalties that are enforceable by DOJ or the Federal Trade Commission. Again, this is, at least it keeps the sort of stick in the hands of the politically accountable branches. I think the interesting question would be, so the DOJ and FTC are instructed to go develop rules that are going to guide the application of civil penalties, and they have a year to do so from when the bill is passed. And the civil penalties can be quite significant, 15% of turnover in the United States or revenue in the United States, which would be an awful lot for a lot of companies. But if these are not going to be imposed except in the most extreme cases, then it will significantly decrease the deterrent effect. So I think what would matter is what DOJ and FTC come to agree on are going to be the thresholds at which they're going to seek really truly meaningful penalties that would deter companies from violations that they're not already deterred by through the prospect of follow-on litigation from the class.
Is that 15% the ceiling?
It's 15 and 30. It's 15% of U.S. revenue in the relevant market, I believe, and 30%. What's the 30% threshold?
If I have that handy.
30% of the United States revenues of the person, partnership, or corporation in any line of commerce affected or targeted by the unlawful conduct.
So and the 15% was on a broader base?
Yeah, it was the total US revenues of the person for the previous calendar year.
Yeah, yeah.
So it's a lot of money for some companies.
Could be, could be. And presumably this would be for things such as exclusionary conduct. Let's talk about how that's covered in the bill. Dan, what does it provide? Just get us started here.
So exclusionary conduct is conduct that materially disadvantages or tends to foreclose or limit the ability or incentive of one or more actual competitors to compete. It's unlawful where it presents an appreciable risk of harming competition, and that the presumption of an appreciable risk is again triggered where someone has market share of 50% or more, or otherwise has significant market power. So I think it's an interesting question to ask, and there are several explicit carve-outs, one of which is above cost pricing, another one of which, so there are a number of carve-outs where they're attempting to roll back some of the judicially imposed rules that have provided safe harbors for a lot of dominant firms' conduct. I think this would have significant implications, particularly for aftermarkets, because they're going to remove, they explicitly say you don't need a history of prior dealing. So any firm that participates in an aftermarket, it doesn't matter if they change their course of prior dealing, if they engage in conduct, whether it's entirely new conduct, that forecloses or limits the ability or incentive or someone to compete with them in an aftermarket, I think that would be an interesting area in which firms might, see a lot of efforts to impose liability. Product design decisions could be captured by this, changing the incentive of someone to compete with you by changing your product design decisions. So, obviously the common law process will have to play out, but I think clearly there'd be a lot more ability for the private bar and the government to bring cases that are currently or perceived as foreclosed by a safe harbor.
Melinda, do you see that as a barrier to a practice?
Well, I certainly agree that this removes a lot of the noise from cases that have said, well, this one doesn't count, and this one doesn't count, and this one doesn't count, right? So the section of the bill says, right, this is all exclusionary conduct, and you don't have to find, and then it goes through this list of not that case, not that case, not that case. So it's, you don't have to find that the entity terminated or altered a prior course of dealing, right? That's always a defense that's coming up. I don't have to deal with them. I'm not doing anything wrong. I didn't alter my prior course of dealing. They're saying you don't have to find that. You don't have to find price discrimination. Basically throwing out Brook Group, you don't have to find that pricing was below any measure of cost or that there was likelihood of recoupment.
And I think you already covered Aspen skiing, right?
Correct. Yeah, that was the first one,
right.
Terminating
that. I think the circuits are divided in that, but it would resolve that question.
Right. And basically throwing out Ohio versus American Express, right? You don't have to find effects in both sides of a multi-side platform market. So you can bring a case and show exclusionary conduct if you are a competitor on one side of a platform. It doesn't matter what's going on the other side and if that other side was harmed, which I think that to me is a real I guess boon to those nascent competitors that would like to be competing, but are going to get advice under the current law that, well, you could bring this case, but unless you can show effects in this market you're not in, it's probably not going to work out for you, right?
Well, would that arise apart from well, this way, if it's not a transaction platform and it's not a sport like Sabre, would anybody really think that they have no cause of action because they're on one side of the market?
I mean, I'm sure that there will be strong defenses for a number of different kinds of platforms, whether it is an advertising platform online, a social media market online. I was just rereading the dissent in Ohio v. American Express, and they really point out, like, basically every market is two-sided. And so, you know, taken to extremes, you can really, it's why all the private cases now, you're always seeing these, oh, but it's a two-sided market defense.
I guess, is there any opinion out there other than Saber?
I mean, as a practitioner, I'm always concerned about the defense being overused, because there are platforms that are two-sided transaction platforms where you should look at both sides. But I saw an example of a case, Melinda, an example of what you're talking about, where there was a private action brought against a group of dental insurers, and the dental insurers alleged that, you know, they responded in a motion to dismiss and said, well, we're a two-sided transaction platform, and we bring together the dentist on one side and the patients on the other. And I thought that the district court judge in that case did a really good job of explaining the concept of simultaneity, that in that situation, the insurers were not selling a transaction. The people, the patients pay their premiums regardless of whether they're getting insurance in a particular month. And then the insurers pay out based on when the service is provided. They are not selling a transaction that occurs at one moment, unlike the merchants in Ohio v. Amex. So I do think that there are distinctions in different industries. You know, to me, the concern is when, for example, in the case I tried for the government, in United States versus Saber, where the Ohio v. Amex opinion was extrapolated from the Sherman Act Section 1 vertical restraint context to a Section 7 merger context. And taken to its logical extreme, the district court's opinion in US v. Saber basically means if you are a two-sided transaction platform, you can buy up everyone else in the world except for another two-sided transaction platform. It doesn't matter how big you are. It doesn't matter what the direct evidence of competitive harm is. You can do it with impunity. The only other thing that you cannot merge with is another two-sided transaction platform in exactly your two-sided two markets. And I just think that that is not what Justice Thomas intended in the Ohio v. Amex opinion.
Was the judgment in that case vacated?
Yes. So the United States versus Saber opinion has been vacated.
As moot?
It's interesting. I thought the Third Circuit's opinion vacating it was interesting, because they say, I think they said it was moot, but then they had a little line that it doesn't undermine the precedential values. So I think a lot of folks are throwing that around these days.
That's very curious. Well, for anybody who's not familiar with the case out in the audience, if it was moot, it would be because the UK CMA prevented the transaction from going forward. So there really wasn't any prospect of its being a live issue.
That's right.
But surely that's a sport. I mean, that was a crazy opinion. Right? It was based on a sentence taken out of context, as you were suggesting, way out of context.
Yeah, I think it is probably an aberration and probably not the norm. But it does raise an interesting question as to whether or not concepts or the way we define markets in merger cases should be the same way we look at markets in Section 1 cases. And so I think that the bill, the Klobuchar bill, is interesting. Maybe it obviates the need to even fret over this question because of the way that it talks about market definition.
So the exclusionary conduct provision, we've got these targeted overrulings, Brook Group, Aspen Skiing, maybe Saber, and some very broad invitations for the government. Laila, do you want to weigh in on this?
Yes, just a couple of comments, and some of them are also just really in the form of questions. So I think read in the bill, with respect to exclusionary conduct. So it says that, it's very clear that the idea is that the practice that's presently in place with respect to the laws is not prohibitive enough, and so one of the things is that they want to try to block others from a fair chance to compete, just because if they don't have a fair chance to compete, it's a violation even before a monopoly results. And the one comment I had when I was reading that is, it sounds different from generally how we've been thinking about injury, and where it's usually you have to show that the customer has been injured, whereas this appreciable risk or this risk standard seems to be, and maybe this goes back to what Melinda was saying earlier with the preamble, that there seems to be more of a focus here on harm to competitors. And if there's harm to a competitor when they're early on, and perhaps there are no price effects yet to point to, that in itself is problematic. So that was just a comment, but also in a way a question for others, in case that's your interpretation of it or not. And then I have a couple of other comments as well.
Well, I'm happy to jump off that for a second. So as a member of the private bar who brings these cases, I don't see, and maybe I'll figure it out, but I don't see this statute as being a big boon for the class action bar because of this appreciable risk, right? You're not going to bring a class action about a risk of something happening, right? You need to have some damages. But I do see it as very useful in also to bring together what Judge Ginsburg pointed out in aligning US antitrust law more with European abuse of dominance cases, and that this exclusionary conduct section in particular, I really think is an excellent source for competitors to be able to muscle their way in and actually get to compete, because so often they're just excluded before they really get to even develop their business. And I think that appreciable risk, those nascent competitors can come in and show that, and then get to compete. And they don't need damages yet, right? They just want to have a business.
Right. And so I think this goes to the next point, which I think you've already touched on, and which is also a question, which is, what are the red flags for appreciable risk? What will they be? And I'm not purposely speaking about presumption yet, because I know obviously there's a presumption aspect with respect to the exclusionary conduct piece of the bill as well. But is it a movement away from looking at actual harm to some red flags of what would create a tendency of seeing something problematic in the future? And it sounds tough to figure out what are those things, and what would the if it's presumption, and then it'll be on the defendant's side to convince that there's no appreciable risk. What are those red flags that need to be knocked down, or if you're on the plaintiff side, what are the red flags that you have to put up?
I do think that the exclusionary conduct piece of the bill sort of makes for the plaintiff's bar, almost puts them in a position of, it's analogous to maybe where the government is in a merger case, because if you have a company that has 50% or more market share, they're going to be able to meet a lot of their burden just by showing market share, which they're not really fully able to do today. Today, you've really got to present that evidence of competitive harm. So I think it makes the job of the plaintiff's bar easier in certain circumstances. But I still think that ultimately, they have to bear their burden of proof to show that there are anti-competitive effects, and the defendant still does have would still have the opportunity to rebut that by showing that their conduct has pro-competitive benefits.
We have a question. Well, let me, before Laila, were you about to say something, please?
Just one more comment on this was, when I look at the presumption part of it that says exclusionary conduct shall be presumed to present an appreciable risk of harming competition with respect to a relevant market if the market share is greater than 50% or otherwise there's significant market power, unless the defendant can show with a preponderance of evidence that there's pro-competitive benefits or there's entry or that there is no appreciable risk of harm to competition. And so I was thinking with respect to economic analysis, and in some ways if this were to go through, it's about what type of an economic analysis will be done at the different stages. And it seems to me the first thing would be that there would be a focus on whether the plaintiff can establish the presumption and if the defense can defeat that presumption. So there'll be quite a bit of focus, I would think, first off on market shares and market definition. And then, because that's sort of the starting point if you were trying to defeat the presumption. And if you can't, then of course, I understand the defendants have to put forward certain evidence, which with the preponderance of evidence, which is different, of course, from the standard today.
So would we have two successive proceedings, essentially bound into one? First on the presumption, then if it gets displaced, then the one which we're used to?
I wonder, I would just expect that first it could be that the investigation is on the presumption before, and because if you establish it or defeat it, it would make a big difference. And maybe it's just a question of, opening and reply reports and so on, and when you get your turn for each side.
I think it's probably more likely to be similar to like the merger trials that we see today, where the government typically does focus part of their case on establishing that the deal triggers a presumption of competitive harm using market shares. But we have the Baker-Hughes burden shifting analysis, where the defendant is able to rebut that presumption by showing, whether there's entry or whether there are efficiencies or whether one of the firms might be a flailing firm or the weakened competitor. They can present that evidence. And then the government bears the ultimate burden of proof, ultimate burden of persuasion to show that the anti-competitive effects outweigh that rebuttal evidence. But what ends up happening is you don't have different proceedings. It all happens in one. And the reason is because the witnesses, as a practical matter, are speaking to all of these topics. You'll put on executive testimony. Sometimes in the government's case, the first person who testifies at trial is actually the CEO of one of the defendants. And so I think as a practical matter, that's probably likely to happen in these private exclusionary conduct cases as well. But I don't know, Melinda may have a different view about that.
No, I think that's I've never sat in a merger proceeding before, so that's interesting to me, and it makes plenty of sense.
It brings up a related question that someone in the audience has sent us, which is, do you expect that the agencies would approach second requests any differently from the way they have under prevailing law now? Dan, that's in your wheelhouse, isn't it?
A little bit. I'm struggling with why that would be the case. I mean, I guess the question would be, would we feel an obligation to inquire more broadly, or would we be able to in some way narrow it? I guess I'd have to think more about that.
Well, I think it might be that if there are more avenues to liability, there are more questions you're going to want to be satisfied about.
Yeah, and certainly the monopsony issue, I mean, we'd have to, in a lot of cases, we'd have to ask questions about labor markets and purchasing. If you have a high concentration in a certain area, whether that's a high concentration of employment, this was an issue. It's an issue that you run into when you're talking about coal mines or other geographically concentrated industries. Would you should you always be looking at the monopsony side? Is that, or would those, purchasers be able to monopsonize local purchases of a particular input? They're going to call that an efficiency because they're going to lower their costs, but all their suppliers are going to come in and say, well, that's monopsony because now I've only got one person to sell my widget or whatever to in this particular geographic area. So I guess it could impose some obligations to look more broadly in second requests. On the other hand, if it makes our jobs easier, then maybe we wouldn't have to burden companies so much because we would feel pretty confident we could win with a somewhat less intrusive examination of every single detail of how they sell their products.
Dan, do you think there'll be more second requests? Maybe not so much because of this particular provision in the bill, but because of the other provisions relating to the merger presumptions or the burden of proof, for example, and maybe vertical deals that are of a certain size?
No, that's an interesting question. Would there be more second requests, or would companies know they have to come in and make this demonstration? And so they'd be prepared to come to the table with, look, here's a ton of information I'm going to give you because the rules are quite clear. Congress just told you exactly what you need to do. So I do think what Congress is trying to accomplish is more aggressive enforcement, more aggressive inquiry, and they're going to give us a heck of a lot more money to do it, apparently. So hopefully we have resources.
Authorize a huge increase in the agency's budgets.
I'm sure we can put it to good use, but I do think, that is what Congress is trying to accomplish. And I do think that it's an interesting question. If we weren't given more resources and we were given this mandate to investigate all of these different areas of transactions in these lines of commerce in the monopsony context, could we do it? Or is this part of a unitary package where if we're going to be investigating all of these issues, we need more resources to do it? That's an interesting question.
Let me throw something out. It may seem to come from left field, but it seems from the discussions we've had that touch on mergers, and particularly if the bill becomes law. What about resurrecting the Expediting Act? Haven't had a merger case in the Supreme Court decided on the substantive issue since, was it 74, I think? 1974, not 1874, but a long time ago. And of course, once the Expediting Act was taken away, a deal that's dead in district court is probably dead. Right? You get the occasional appeal, depending on what's been negotiated in the contract on acquisition, but nobody can wait for cert and review in the Supreme Court. I'll tell you a brief story about that. There was a case involving a beef packing acquisition in Colorado. I remember the name of the Monfort of Colorado was the company. And I was then the Assistant Attorney General for Antitrust. And I decided I would file an amicus brief in this case. And it turned out that the lead lawyer for the companies was Ron Carr, who was at Morrison & Forster and was a classmate and friend of mine. And I called him up and I said, Ron, I'm going to file an amicus brief on your side of this case, but I have a question. Why are we in the Supreme Court on a $15 million deal? And the answer was, local counsel forgot to provide that we don't have to pay for it if we don't get it. So it was a complete fluke, and it hasn't happened again since. So if we're ever going to get the Supreme Court to tell us anything about Section 7 or the revisions if they are passed, it's not going to happen without some sort of expediting mechanism.
I think that's a good point. It's a little above my pay grade, but I have heard intelligent people make the point that if the court was forced to take cases and didn't get to pick them, you would have a more traditional common law process in which we would get the court to weigh in on different fact patterns instead of waiting to pick a case that they really want to do something with to change the law. And also, to your point, it's going to be a heck of a well-capitalized and patient set of companies that can sit through the process and get to the Supreme Court under Section 7.
Yeah. No, it's usually just not practical. Oh, well. Laila, you were going to delve into market definition a bit, right?
Sure, and we've touched on this a bit, so I won't be too long with this.
Was it Julie? I'm sorry. Of course. Yes,
Yeah, no, I think it was me.
No, you're right. You're right.
So the Klobuchar bill would eliminate the market definition requirement where the plaintiff or the government has clear evidence of competitive harm. And I think that's a biggie because lots of antitrust cases founder on the market definition requirement. And by way of example, we have the Ohio versus Amex case. We have the US Air versus Sabre case from the Second Circuit. And we have the United States versus Sabre case, the one I tried last year from the Delaware District Court. And in each of those cases at trial, the plaintiff or the government presented substantial evidence of competitive harm at the trial. But all of those cases foundered on market definition. So this particular requirement would have changed the outcome, perhaps of all of them, but likely of at least some of them.
What is the logic of dispensing with market definition and deciding that there's an anti-competitive effect when it may turn out they're not really in the same market?
Well, as a practitioner, I think that market definition is very important. You've got to be able to have a lens through which you evaluate the evidence. And I find it very hard to understand how you can eliminate that requirement altogether. I view sort of the evidence in your typical antitrust case as being a three-legged stool. You've got your evidence on the ground, the ordinary course documents, you have the testimony of fact witnesses, and then you have your economic expert testimony. And I think all of those things work together to paint a picture that is both quantitative and qualitative. And I think market definition is a part of that. You know, are we over relying in some cases on economic modeling over fact witnesses? You know, that's a debatable question, but I think that dispensing with the requirement of market definition altogether is problematic or could be problematic. Others may disagree.
Yeah, before we turn to Laila, you just asked whether Melinda or Dan have a comment on that.
Yeah, I mean, I was just going to ask, you know, for example, in the three cases that you named, including the US v. Sabre case, where, you know, you said there was evidence of harm, and that if you didn't have to prove a market definition, then you would have won. I mean, you're still proving but for causation, right? So it seems to me like as long as you're proving that it is that conduct that caused the harm, then I don't really care if they're in the same market or they're not in the same market, right? The conduct caused the harm.
I guess my response to that is I don't see the need for a bill that is this, I'm going to say the word radical because it comes to mind, but I don't necessarily need radical, but I don't think you need an overhaul of a requirement quite to this extent in order to solve that problem. And the reason is, at least in the case of the Sabre case, you had the brown shoe precedent, US versus brown shoe, a very old Supreme Court case from the 60s that says in a Section 7 case, to define the market and evaluate the effects of a merger, you look at where the overlaps are between the two merging parties, and you evaluate competition where, in fact, competition exists. And so it does give instructions for how to define a relevant market. And in the government's view, in that case, we believe that we follow the instructions of brown shoe and we're able to establish the brown shoe factors in that particular case. So, you know, our argument wasn't we don't need to prove market definition. Ours was we proved it, and we proved it under brown shoe. But instead, you know, that was not important or not relevant or ignored. And instead, Ohio versus Amex was, you know, elevated to, I don't know, ignore that or cancel it out. And so to me, I guess my conclusion would be, I think that the tools presently exist to avoid problems like that without having to pass a new bill. But others may disagree.
Dan, you disagree?
I have no disagreement. I mean, it's difficult. I think Julie's exactly right. It's hard for us as antitrust practitioners to understand how we start thinking about anti-competitive effects because we always start from the market definition. If the law were to change and we were to instruct district judges, I don't think we would stop presenting evidence that's probative of competition in the relevant market. But it might allow district judges who aren't necessarily steeped in these concepts and aren't necessarily interested in these concepts to accept direct testimony of customers who say, I'm not going to have any ability to switch my purchases. My prices are going to go up. I sort of feel like asking sometimes, why do you think these people are lying? What incentive would they have to come to this court and lie if they really thought they could protect themselves? Their customers are scared. These merging parties haven't done a good job at convincing their customers the prices won't go up, or their customers don't trust them. Why aren't we done here? And if what that founders upon is a complicated econometric demonstration that people could use different assets in different ways and ship things that are not currently sold in the market into the market, why are we putting district judges to that burden? Why are we trying to force them? Why are we making their lives hard? If we can give them direct customer testimony, give them business person testimony that suggests that prices are going to increase and that market power will be created, maybe a change in the law that clarifies we don't have to meet this rigorous set of technical definitions. We give the district court some ability to trust that instead of feeling like they have to answer all the econometric questions, the threshold matter. But I do think the law is fine as it is in the sense that market definition does point us in the right direction. Market definition does help us identify the transactions that are problematic. So it's not as if we're going to stop using these tools at the agencies, and it's not as if we're going to stop trying to explain these concepts to courts, even if you were to tweak the law a little bit and say it's not required.
No, I think you both put that really well, which is everything would be fine if the courts had enough time to actually absorb the facts of both sides and not get confused with, sorry, Laila, econometric analysis. And that really what the bill is trying to do, I think, is just make it less technical, make it simpler, right? Make it more common sense.
Yeah, so I think on this topic, I think, I'll just start by saying, if let's say there's evidence of price effects and there's, the market definition exercise hasn't done. So I'm speaking about litigation. So let's say exclusionary conduct case or something. I think given that when there is evidence of price effects, there can be issues related to interpretation. There are often even serious causation issues. I think it helps a great deal that there is the discipline of a market definition analysis, so that it's all the economic evidence is seen together, as opposed to potentially making a costly error by looking at only a price effects analysis. And that doesn't mean that I don't think that price analyses of price effects cannot be extremely useful. I think they can, but there is a concern that that they can be interpreted in different ways. And so I think that market definition exercise is very relevant to try to avoid errors.
So has it become overly technical or extended in an actual litigation where you have competing experts on market definition?
Well, I think we've seen some judges say that. For example, we had the opinion, I guess it's been about a year ago now, from the court in New York versus Deutsche Telekom, which is the merger of T-Mobile and Sprint, where it was a very long opinion. It was a fairly long trial, and the court said, both sides presented competing expert testimony, but I think those canceled each other out, and I find what the CEOs told me persuasive. And I remember going to the ABA spring meeting in 2019, and I went to 2 different panels of judges, and I thought it was really interesting how the majority of the judges on those two panels said that they felt that we were, antitrust lawyers were over-reliant on expert testimony to carry their case, and that what they found more persuasive was the fact witness testimony and the ordinary course documents. To find a persuasive expert that's able to tie those together and tie them to your case, but not to be over-reliant on experts to carry the water for the case. And that really stayed with me.
So I think I won't speak about mergers and sort of that value of the customer testimony, but if just speaking from experience in litigation matters where there are, say, references to documents which are saying here's what happened with prices, or prices for a bunch of customers went up. I think as an economist, those are testable propositions, and that doesn't mean that, I think, Julie, you said earlier, these things can be married, and I think that is exactly what should be done, is that you don't just take the documents and rely only on those, because you can test and see whether, when push comes to shove, how did things play out? Was it the case that prices did go up for a bunch of customers? Could some avoid it? Could some have avoided it? Did they? What proportions? I mean, there are just so many richer questions that can be answered once with the information that is available in discovery. And so I wouldn't, as an economist, especially one who focuses on a lot of empirical analysis, I wouldn't think in that case the documents are sufficient.
The way you described it, it sounds like something on which the two economists would have to agree.
I would hope.
Has that
so.
ever happened?
No, of course not. You say, well, it's a testable proposition, why can't we all reason together, right?
I mean, to me, I think that's an interesting point, and I don't think I completely agree that obviously econometric evidence can be incredibly enlightening. It can show you what happens over large numbers of observations and provide a much richer picture than one document or one person's unsupported declaration or offhand comment in an email. On the other hand, the fact that you can always get two smart PhDs to disagree with each other leads me to believe that perhaps the limits of our data, not the limits of our economists' honesty, is the problem. And so if they're unable to present one another with data that actually convinces an intelligent economist of goodwill on the other side, maybe making it simpler for district courts is a path that the judges would appreciate. Because if not even an economist can understand if the other side's data is good enough to prove the point, what chance do us mere mortals have who are just lawyers?
So I don't think it's a matter of it shouldn't be a matter of but I think I know what you mean when you say disagreeing about data. I think often I understand these disagreements are about the methodology, or what factors have been accounted for and which have not been. And so yes, there are a lot of disagreements, and I guess that is ultimately why it's a fact-finding exercise.
Well, this discussion leads almost inevitably, more than just naturally, to this practice that some judges have instituted of putting the economists in a hot tub, so-called. Can you describe that procedure for us, Laila?
Sure, yes. So I think the official name is concurrent expert evidence. And so the practice refers to when experts from both sides will be, will under oath take the stand at the same time in front of the judge and engage in a discussion about whatever issues that the judge would like to discuss. So in my personal experience, I think I had shared just in the last, I would say in the last year, so 2019 and 2020, I've had the opportunity to be in two different hot tubs in front of Judge Donato in the Northern District of California. And in each case, and each time the format was similar in that they were the experts from each side. In both cases, Judge Donato was looking to have this discussion to determine where he was going to come out on Daubert issues as they related to the methodology of the opposing experts. And I thought it was so just quickly on format, and then I'll give away what why I think it's a tremendously useful exercise, and then turn it over to others. So the format was that the experts had to decide ahead of time together in a joint statement what they thought were the key areas of dispute that, as they related to the Daubert motions, of course, that were already pending. And then we went into the hot tub with Judge Donato, and he chose the order in which he wanted the topics to be discussed. And each expert got to give opening remarks and then and provide responses. And Judge Donato mediated that discussion and allowed that to continue up until he was ready to move on to the next topic. And so the judge asked questions, the experts provide responses. There was cross-examination as well at the end from the attorneys.
So before the cross-examination, were the attorneys gagged?
I'm sorry?
Were the attorneys not permitted to interject, intervene, or seek to counsel your testimony?
So the cross-examination was left to the end. So during the discussion, Judge Donato had made it very clear that his preference was to do it like an academic seminar. He wanted it like a discussion. And then he allowed an opportunity at the end for the attorneys, if they wanted to ask questions of their own witness and then also cross-examine the other witness. And just quickly, and I think related to the point, so it was a perfect segue, is that I think this is, of course, it's a non-jury setting, and I think it is a tremendous opportunity, I think, for both sides to make sure that some of this, as we've just been saying, that the evidence can be complicated. It's sometimes difficult to explain in simple terms. And I think it is a really tremendous opportunity for both sides to be able to explain the issues to the fact finder, and so that they can be better understood. And I think, I think it's really only positive in my mind, but I can imagine that attorneys disagree to some extent.
Any attorneys there who disagree?
I'll take a shot first, I suppose. That Judge Donato's procedure sounds to me like it answers some of my largest concerns about the idea that there would be some sort of hot tub. And that's not surprising. Judges are smart and they know what's going to be effective to them. My biggest concern when I heard about this is we have a process for disclosure of opinions that allows the attorneys to object if opinions are not disclosed properly. I think there's already too much incentive for economists to kind of withhold critiques of one another and then attempt to surprise each other at trial. And I wouldn't want to create a situation where they don't put something in their rebuttal report because they want to zing the other person with it in the hot tub. That doesn't necessarily serve anyone's purpose as well. It sounds like Judge Donato, by clarifying the issues in advance, solved that problem and would have provided the attorneys an ability to object if there was some undisclosed critique or undisclosed analysis. But that was the first thing that jumped into my mind is we have an opportunity to attempt to clarify it for the court in direct examination. And I have the opportunity to object during the other side's direct if they start saying things that aren't properly disclosed or I haven't had a chance to test, and likewise in cross-examination. So obviously we all want the judges to get the best thinking the economists have to offer. It's not clear to me why the sort of process provided by the federal rules is inadequate to that purpose. But if judges feel like they're not getting, if lawyers aren't getting down to brass tacks quickly enough, if economists are being too evasive, then I completely understand why they would want to have more control over the questioning process. But I feel they have that if they want that anyway. I mean, the economist is in front of them, they can pose questions directly to the economist. And lawyers get to write the rules of civil procedure because we want to be important and we don't want to have economists become super advocates who are famous for their amazing zingers and hot tubs and start getting paid a lot more than we do. That would be a terrible turn of events. And I think we need to discourage that at all costs.
Yeah, and then we'll risk having cartels of economists, highly paid economists that are good at hot tubs, and there won't be very many, and we'll have our own monopoly problem there.
Absolutely investigate that.
So just a couple of comments, if that's okay. So I think on this issue of, so this is not supposed to, I think this is about there being a learning tool that's available. It's not that there's some substitute to trial or something like that. But here's I think a distinct advantage, in my opinion, compared to what would normally take place. Of course, there's the exchange of the reports, there's depositions, there's vigorous cross-examination and all of that. I think what's very helpful, I found, is that you can have both the experts speaking about the exact same issue. It might seem like a subtle point, but what I have generally seen is that it's not always very easy to have both experts be speaking about the exact same issue. It might be that their direct and cross-examination is separated by, say, some days or over the course of the day, and this really puts, and again, it's really up to the judge if that's what the judge wants, is that you get to ask directly and say, I'm talking about this specific issue, I want to know what you think. And let's say, you give your opinion, and then the judge turns to the other expert and says, why do you think that's wrong? So you don't get to address something else, you have to address that exact issue. And I think that, to me, is really a great benefit.
I can see it being particularly useful in the class certification context. That the class certification hearing has now become a mini trial, and it's not an issue for a jury. It's an issue that the judge is considering anyway. Right. And it tends to be concentrated over usually a couple of days. So, I can see some value of that process there.
The rules also permit the court to appoint its own expert. Has anybody ever been in a case, a case in which a judge has done that? I know it's not that frequently done. Judge Posner thought it should be done more and criticized district courts for not doing that, partly in patent cases, but also in economic cases. And of course, there's the example set by Judge Wyzanski in the United Shoe Machinery, where he enlisted as a law clerk a person who became a very prominent economist, was then an assistant professor at MIT, and that was not disclosed to the parties. And of course, it was defended on, it can be defended in the same way that the judge could read a book, but it seemed to be a little bit different than that. But anyway, do you think it would be a bad idea in cases you've been in to have the judge appoint a third economist?
Who pays the court-appointed economists?
Parties.
Yeah, that doesn't seem fair to me, to impose on the parties a third person. I mean, who's picking it? The court is picking it? Like, yes. Right, we have an adversarial system for a reason, and the parties should get to choose who they're working with. And I mean, just like Dan said, the economist for the plaintiffs is going to say one thing and the defendant is going to say the exact opposite. So why do you need somebody, in the middle, right?
Well, perhaps to say, at least if there's no hot tub, say, Judge, look, the difference comes down to this. This is being open court. The difference comes down to this, and I think so-and-so is more in line with the way economists think about this issue. It can be rebutted.
I agree. I agree with that as well. I would welcome it, because you can also have a special master or a court-appointed expert on very specific, narrow issues, and if that is something that would be of help, because a lot of these things, when we're dealing with them in antitrust cases, do come down to methodology, and so I think it can be useful. But I've heard the concerns that are being mentioned about a court-appointed expert.
Julie's raised this point about class cert becoming another trial of economists. So, Laila, what you mentioned this not in the program, but earlier. What is this issue of ascertainability that you're concerned about?
Yes, so I think one of the issues that sort of come up is whether the Third Circuit has a heightened requirement for ascertainability. And of course, the lawyers will be able to speak more about this, but just to tee up the issue. So the question, as I understand it, is and there are a couple of examples of cases I can give, which is the class that's proposed, is it administratively feasible to identify the class members? That's my understanding of ascertainability. And there've been a couple of cases, well, there've been a few cases in the Third Circuit, and I'll mention a couple of the antitrust cases. So drywall was one, domestic drywall. Another one was eggs, where in each of those cases, the court denied class certification of indirect purchasers, so end consumers, and in domestic drywall, this was the main reason, said that it was not possible to ascertain who the class members are, and that is a requirement for class certification. And in eggs, there were other concerns in addition to ascertainability, concerns about predominance, but in eggs that was brought up as well. And as I understand, the Ninth Circuit doesn't, and Melinda will be able to speak more about this than me, but I understand the Ninth Circuit has a different view on whether ascertainability is a requirement for class certification or not. And then there are courts and other in different circuits that differ. So, but Third Circuit does come up often in this context. Melinda, did I do a decent job?
Absolutely.
Okay.
Well done. Well done. So Laila brings up this, and it really is the Third Circuit does stand out as having, although it is already walking back this heightened ascertainability requirement. So what happened around a few of those cases is the defendants, made a pitch to the court that in order, and classes do have to be ascertainable, right? You have to be able to tell who's in the class. One could say that having an objective class definition is all you need. But what the defendants had put out there kind of was wrapping it in the predominance difficult case law and saying, well, the only way to have an ascertainable class is if you've got one database that identifies everybody. And this Third Circuit, said, yep, agree, and then has been walking it back in cases ever since, pointing out that, like, well, wait a second, why is it impossible to have class member affidavits? You don't need to know every single, let's say it's a consumer class, you don't need to know every single human being that is in a class before there's any money to distribute. You need to know basically who is in the class, and you need to know the total amount of class damages. And beyond that, it's pointless. You don't need to know who's in your class. We don't have, the whole point of a class action is that it's not, individual A, B, C, D through 23,000. You have a group that is defined a certain way, and you may eventually have a pool of funds to distribute, and you need to know who to give those funds to. But until somebody claims it, you don't really have a problem. And so what evolved over the cases was more of a tolerance for accepting class member affidavits, people saying like, see, I have a receipt, I'm a class member, that kind of thing. And that's ascertainable because you can tell that they are a class member, even though you may not have known their name from some database before. And it's Laila's right, it's really the Third Circuit. The Second, Sixth, Seventh, and Ninth Circuit have all rejected the heightened ascertainability requirement, and I don't think the other circuits have addressed it.
I think in Nexium, the first, and this was not class certification, but I think in Nexium, the First Circuit said something about needing to, well, the court said needing to show feasibility in the liability phase, that was important. And actually, I testified in a matter in the 11th Circuit where this was a false advertising case, and that was denied also on ascertainability, for ascertainability reasons.
Yeah, I think it's just an example of the courts interpreting the class certification requirements more stringently over the last couple of decades, really. And, you know, I think we see some examples too with how courts are dealing with the predominance requirement under 23b3, where if you have too many members of a class who were not damaged, having too many of those in a class can make the class not meet the predominance requirement. So I think what you're describing is another example of that. And it'll be interesting to see, especially with the composition of the Supreme Court right now, as cases go up, how the Supreme Court, with 3 nominees from President Trump, how they will deal with matters that come before them on this topic.
Thinking about eggs, a class action for egg consumers, direct or the indirect purchasers, does seem to me rather daunting to imagine that you could discern or even get enough people to come forward who meet the description of, let's say, having purchased eggs at a grocery store between a certain date in 2014 and a certain date in 2018, and have some receipt or other basis for making that claim. I mean, so if we follow what you're saying, Melinda, you generate this pool of money, and then there are just a few peculiar individuals who are in a position to first get notice and then come forward. And then what happens? It's all then the big slice is, of course, for the litigation, for the lawyers, and then the rest of it goes what, side prey?
Well, I would argue you've given another great example of ways that we can actually track people that aren't necessarily one database. It could be a receipt, but people also use those, the discount card at the grocery store, and you could subpoena the records from the grocery store. But I think the larger point is, the point of a class action is not to get together a giant group of people. Individual people who all are saying, please, I'd like to join this case. It is an opt-out class action regime for a reason, which helps deter, in antitrust cases, anti-competitive conduct, deter the conduct, give some redress. And if class members are overcompensated as a result of not enough people filing valid claims, which I don't think has ever happened, that's not the worst thing that could happen.
So, and side prey, of course, may go away in another term or two in the Supreme Court. So you'd have this pool of money, and the egg purchasers say, well, I can prove I spent $30, but my pro rata share is $10,000, right? I mean, so you're getting a little overcompensation, yes, but you want to get the deterrence. I mean, at some point, maybe you just have to return the money. I don't know. This is a vexing one. I haven't come across this.
Yeah, it's never happened.
Yeah, good point. Okay, well, I want to thank you all for being such a great panel here, and as well prepared and articulate as you've been. So this does conclude our session. The symposium will continue tomorrow at noon. The next session is on the future of FTC remedies, a very important matter that's pending in the Supreme Court now. And I think it's been teed up more than once, but the court didn't get to it last term. So we're all waiting on that. And the discussion tomorrow will, I think, do a lot to illuminate what we think about that case. So beyond that, tomorrow then on Friday at noon, we'll have the finals in the 7th annual 7th annual Global Antitrust Institute Invitational Moot Court Competition. The judges will include Ian Forrester, until recently the British judge on the European General Court, as well as Tim Muris, former chairman of the FTC, and myself. I hope you'll all come back and root for your favorite team when you see them on the playing field. Thanks again to the panel. Good night to all. See you tomorrow.
Good night, everyone.
Thank you so much.
Thank you, everyone.